Ready, start. Clause 7 provides that the location of the plot may be changed if the government or any statutory authority requires a change in the existing layout plan. During arguments, we inquired of Mr. Nayyar for the respondent to show the basis for invoking Clause 7 of the agreement, that is, to show us that the layout plan was sought to be changed by the government or statutory authority. In answer thereto, it was submitted that the alternative allotment was made in the year 2011. However, till 2018, the appellant raised no demur as regards the same. The answer is neither here nor there. Whether or not the appellant raised a demur is not relevant for validation of the respondent's conduct. Also, the basis for offering such alternative allotment has not been disclosed in the written submissions filed by the respondent. Be that as it may, the position of the alternative plot within bracket allotted in the year 2011 bracket close was offered only in the year 2018. Having noted thus, we agree with Mr. Nayyar that before compensation can be granted by the NCDRC, actual loss must be proved to have been suffered by the consumer. The objective of granting compensation cannot be altered such that it amounts to a windfall gain to the other party. Proof of actual loss would require evidence to be tendered, for it is a guiding lamp for grant of compensation. Be that as it may, in this case we are not deciding the actual loss suffered by the appellant. We are only concerned with deciding the rate of interest to be awarded to the appellant on the principal amount paid by him to the respondent. Keeping in mind the overall conduct of the respondent, the delay caused by it in offering the plot, the fact that the respondent charged the appellant delay compensation at the rate of 18% per annum on the due amount, and the long wait that the appellant had to endure over a period of a decade, causing harassment and anxiety which are writ large, we find that this is an appropriate case where refund of the principal amount with interest at the rate of 9% per annum as awarded by the NCDRC will not serve the ends of justice. In view of the conduct of the respondent, it cannot be permitted to escape with a normal liability for its default while it charged interest at the rate of 18% on default committed by the appellant. Although the rate of interest charged by the builder cannot be granted to the buyer as a rule of thumb, however, in the present case, equity and fairness demands that the respondent be put to the same rigors for charging 18% interest and face consequences similar to those imposed on the appellant for default committed by him. If we hold otherwise, we will be perpetuating a manifestly wrong bargain. We therefore substitute the rate of interest awarded by the NCDRC and increase it from 9% to 18% per annum while keeping the other terms intact. Respondent shall refund the requisite amount.